Welcome to Partners Managing for Impact webinar series. My name is Balson, and I will be presenting on the basics of corporate governance. While an exhaustive discussion of corporate governance is not possible here, this webinar will be focusing more on a high-level overview of the legal requirements and considerations for incorporating an organization, preparing articles and bylaws, and including the board of directors. Each is worthy of more consideration than we will be able to provide in this short presentation. The goal here is to flag potential issues, get them on your radar, so you're aware of what to look out for and can seek out further information that will be helpful to the particular circumstances of the organization. Governance, this term we hear so much about. There's no definition. Corporate governance is a broad concept that's intended to capture the ways in which organizations are led and directed, their mechanisms for accountability, and the relationships between the various internal and external stakeholders of an organization, for example, between the board, the operation management, the members, the community, and other stakeholders. I'm going to refer continually throughout this presentation means those individuals that are admitted as members to the organization. Shareholders in a for-profit corporation scenario. Corporate governance rather than on, say, growing the particular activities of a social enterprise. What is the machinery and structure that facilitates those activities and allows an organization to achieve its purposes and desired results on a consistent basis. It delineates power and responsibility between the various actors to promote efficiency. It puts in place mechanisms to ensure accountability, whether financial or managerial, which in turn promotes trust and credibility among potential funders, the public at large, government agencies, and potential partner organizations. Structures are also extremely important for the sustainability of the organization and for long-term growth. If the organization runs smoothly because of the work of particular individuals rather than broader structures, what happens when those individuals move on in either the short or long term? What happens when the workload becomes too much for that small group to take on, or geographic reach of the organization is expanding? By putting down on paper the governance decisions that an organization is making, it enhances the ability of that organization to replicate that success on a larger scale and with different individuals involved. Strong corporate governance is so critical. Let's start at the beginning with the form of the organization. There are four forms of not-for-profit organizations in Canada: the Incorporated Association, the Trust, the Corporation, and the Federal Corporation. We are incorporated entities in this presentation. It is also just worth noting as an aside that social enterprise is a growing category of social purpose organizations, but it is not in itself a legal business form in Canada. Social enterprises can fit under the umbrella of many different business forms. For yet incorporated your organization, rest easy, there is no legal obligation to do so. An unincorporated association is simply an organization that's set up with the agreement of a group of individuals who've come together to advance a common goal. Countless such organizations operating in Canada at any one time. You may wish to consider the advantages of incorporating and balance those against potential disadvantages. Remaining incorporated reduces the administrative and financial costs of running the organization, which frees up time and other resources to focus on the organization's purpose. Unincorporated associations also have increased flexibility as they are not subject to the same statutory restrictions as corporations. Organizations do not have legal personality, which means they do not exist separate from the personality of their members. This means they cannot sign contracts or open bank accounts in their own name, and that the individual members could be personally responsible for debts and obligations of the association in the event that the association is sued or defaults under any contributions that the members have signed on its behalf. Incorporated associations are not eligible for certain tax advantages, such as being designated a charity. This structure may be an attractive option for small-scale operations. are that it provides the organization with its own distinct legal personality, allows it to do basic activities such as open bank accounts, enter into contracts, own property, survive the departure of certain individuals, and provides limited liability for the members, directors, and officers of the organization. The fourth structure creates accountability through requiring articles, bylaws, the holding of annual general meetings. And it also creates a formal decision-making structure, which improves accountability, all of which may help to increase the credibility of the organization with funders, partners, government agencies, and the public. Is the right way to go. Consider the incorporation should be done under federal law. A good example to the organization carries on business in multiple provinces or is likely to in the future. Or the organization should be incorporated under provincial laws, which is an option if the activities are more likely to remain local within the boundaries of a particular province. Each province's statutes will have their own particular requirements, so it's important to read statutes and to understand what the requirements are in the jurisdiction in which you'd like to incorporate. For example, in BC, there must be at least 3 directors, one of which must be ordinarily resident in BC. Included in the Further Resources section at the end of this presentation some links to the governing statutes for several provinces and the federal statute as well, which are worth taking a look at. How to go about it? Well, it has its own specific procedures. The general requirements are typically the same. You want to conduct a nuanced search, which is a computerized search system that will know if your desired name is already in use. You can select and reserve your name. You'll then read the articles and bylaws, which we'll discuss in a little bit more depth throughout this presentation. You'll also complete a list of initial directors and the corporation's address. Once ancillary documents, you'll file the articles of incorporation. But make sure to abide by the specific requirements of your jurisdiction, particularly if the organization is seeking to be designated a charity, as the purpose of the organization as set out in the articles must be described in a particular way. There are other community groups have often published useful how-to guides on the steps of incorporation for not-for-profit organizations, and I've linked 2 such guides here, which are very useful resources. What exactly are articles of incorporation? Well, they're sometimes called a constitution of corporation or organization, and they can be the operating rules for that organization. These include the maximum number of directors, as well as the classes of members of the organization, and the rights each class may have, such as the right to vote. Taking a long-term view, you may wish to create different classes of members so that as the organization grows, the leader of the organization can admit more and more members, but control and restrict how many members have a vote for practical considerations. Will also contain any other specific rules that the organization desires to impose, as long as those rules don't contravene the requirements of the law that you're incorporating under. Bylaws, on the other hand, contain the rules that govern the internal management of the corporation. So these bylaws will set the rules on membership, on meetings and procedure. They'll provide for the election of the directors and modify or restrict the powers of those directors. And it also provides for the appointment and duties of officers and voting procedures. For example, whether proxies are allowed in the event that an individual member is not able to vote. Jurisdictions have model bylaws that can be used as a good starting point or just adopted entirely if they will work for your organization as already prepared. Please see the further resources slide at the end of this presentation, and I have linked some model bylaws that may be helpful in drafting your own set of bylaws, or that may be helpful by just adopting entirely. Of the purposes of the articles and bylaws, here are some things to think about while drafting them. Different may have different mandatory rules. For example, in Ontario, there must be a minimum of 3 directors. Since corporations and not-for-profit organizations included therein are creatures of statute, as we discussed, there are basic default rules that will apply unless they are specifically addressed in the articles or bylaws. It is therefore really important to be aware of the default rules in the jurisdiction in which you're incorporated. For example, on federal statute, directors can borrow and grant security, which means put up assets as collateral, with authorization of the members. If restrictions on the borrowing powers of directors for your organization, these restrictions will need to be set out in the articles or bylaws in order to override the default provisions. Otherwise, the default will apply even if your articles or bylaws are completely silent on this issue. Your organization and you already have articles and bylaws, consider reviewing them periodically to determine if they are still in step with the needs of your corporation. If changes are required, articles can be amended by filing articles of amendment, which on the nature of the amendment, whether it's something like a name change or changing the number of directors, or something more substantial, such as changing restrictions on borrowing powers, it will require a special resolution of the members or a resolution of the directors. Can be changed by a special resolution. And when we say special resolution, this is defined in different statutes, different provinces. But for example, in BC, and it's the same in the Alberta statute as well, a special resolution is a resolution passed by a majority of not less than 75% at a general meeting, or a resolution that is consented to in writing by every person entitled to vote if there had been a vote at a general meeting. Special resolutions must also be filed with the registrar in order to become effective. These are different than ordinary resolutions, which, depending on the rules that you've set out in the bylaw, can be passed with a simple majority, so 50% plus 1. It can be a bit of a process to amend article bylaws. So it's important to take a long-term view while drafting and to anticipate the needs that your organization may have as it grows. Board of Directors. When it comes to the Board of Directors, the directors all share the same legal duties, which is to act honestly and in good faith with a view to the best interests of the organization, to act in accordance with their fiduciary duty, which is their obligation of trust to stakeholders, internal and external to the organization, to exercise the care, diligence, and skill of a reasonably prudent person, to of interest, and also prohibited from taking advantage of any opportunity that comes their way by virtue of their office as a director for personal benefit. There are annual general meetings to do things like approve audited financial statements, approve amendments to bylaws, elect new directors, elect auditors, and so on. If to breach any of these duties, they may be held personally liable. Third, the individual board members. Let's turn attention to the style of board that may be right for your organization. One-size-fits-all miracle formula, but rather each of these styles may be useful at different stages of an organization's growth. A administrative board is one in which the board members are also running the day-to-day operations of the organization. This format works well where the board members have sufficient time and operating skills, to organizations that have few staff and a limited geographic reach. The administrative boards is to ensure that the directors are aware of and are carefully cultivating their dual roles, as they must still be thinking of their governance role while fulfilling their operating role. Third is one in which the board of directors are still actively involved in the operations, yet there is a significant amount of delegation to employees, committees, and management. This tends to work well with organizations that have staff, have a broader geographic reach, but still rely on the expertise and operation management skills of the board. With the style of boards, duplication of work and blurred lines of responsibility between the various levels can be some common pitfalls to watch out for. The board is the model you will typically find with larger, well-established organizations. In these cases, the board has a clear strategic vision and ability to put in place processes to achieve that vision. There is a clear delineation of operational decisions between the board and operational management, and clear accountability mechanisms. There are well-established board education and orientation practices to minimize the impact of director turnover, and we'll touch on this a little bit later as well. Style of board, it is important to maintain the lines of communication between the operational management, so the CEO or the president, and the board, that there is one united governance leadership structure rather than having two parallel systems. It is consider the composition and structure of the board. Boards may be an attractive option, following in other administrative considerations. But there is also often increased communication. However, boards can be helpful in that they bring together multiple perspectives and skills. There's less demand on the time of a few directors. There's more opportunity for diversity and inclusion, and there's better retention of institutional memory if one director leaves. However, a larger size board may impact efficiency, as the group may be less likely to come to a consensus and may instead be prone to deferring to operational management like the CEO or the president, in which case the benefit of having board oversight and guidance is diluted. During the term of the directors, for example, will the directors be elected to a 3-year term with re-election possible for only 1 or perhaps 2 additional 3-year terms? And considering the length of the term is important in order to avoid a delay and to encourage revitalization by bringing in new ideas and new energy. It's also important to consider in advance succession plans and to stagger the terms of the directors so that a significant portion of the board is not turning over at any one time, and this will help with consistency and continuity. Communication and education is another important component of effective board governance. Each board member should be given thorough information on the culture, processes, history, internal management, and operations of the organization. And open lines of communication from the operations level to the board level and vice versa is also extremely important for cohesion and for the realization of common goals. Final note, it's important to keep and maintain minute books and corporate records. They do not need to be particularly fancy, and in many cases are simply 3-ring binders containing all of the documents. But they are necessary as they provide a record of all corporate action and help to keep track of documents such as the articles and bylaws and any amendments to them, the meeting minutes and materials for annual general meetings, the lists of directors and officers, the approved financial statements, and so on. Records are important as there are legal requirements to maintain them, but they are also an effective means of capturing institutional memory and ensuring that the relevant information is easy to locate for future directors, or frankly, for any potential partners, large funders, or government agencies who may want to conduct a due diligence review into the operations of the organization. To conclude, high level, the incorporation process and governance structures of not-for-profit organizations, and these are more particularly set out in the statutes of the incorporating jurisdiction. It's always helpful to read those statutes, to visit online how-to guides and government websites to understand more thoroughly the requirements and governance options for your particular organization. In this, we've also touched on how well-established and thoughtful corporate governance structures and processes can the organization run smoothly even as it is growing. here are some further resources, namely the governance statutes, and on the following slide, the bylaws that may be helpful for moving forward. Many thanks for your time and attention in this presentation, and please consult these resources. I would like further information on any of the things we've discussed today. Many thanks.